A pin, he must be found to need supervision or...
Treatment.
Right. And what is it with JD?
Supervision, treatment, confinement.
3. The court on its own motion may substitute a blank petition for a PINS petition.
Neglect.
4. A PINS proceeding is originated in the county where
the acts occurred.
Rabbi. 5. Which of the following cannot originate a PINS proceeding? Police officer, peace officer pursuant to special duties, victim of the PINS, a witness, a friend, a duly authorized agency, or the presentment agency when substituting a PINS for a JD.
I feel like I'm cheating because I just did this like 3 hours ago, but it's a friend.
Yes. Okay. And I remember that too because Angela has a good video on that.
She does. She has a really good quiz on it that I'm trying to find right now.
Oh shit. Service of PIN summons and petition must be at least blank before time stated for appearance.
24 hours.
Yes. They're all 24 hours, right? Except for Article 6 is 20 days.
4 and 5 is 8 days.
What?
4 and 5 is 8 days. 6 is 20 days. And everything else is 24 hours.
Oh, fuck. I had 24 hours for everything on my sheet here. All right. Okay, so 4 and 5 is 8 days.
Yes.
Okay, for the petition.
For the service of the petition, yep.
Okay. All right. 7. At a fact-finding, PINS hearing evidence must be...
Fact-finding is competent, material, relevant.
Yes. The standard of proof required for a PINS determination is...
beyond a reasonable doubt.
Yay! At a PINS dispositional hearing, only evidence that is...
material and relevant.
Yes, and I have a good way to remember it. Somebody told me.
Okay.
Mr. Poe at the dispo. So it's material and relevant, preponderance of the evidence at the dispo.
Oh my god! Mr. Poe at the dispo, okay.
It helps.
Oh my god, okay.
Okay. 10. Petition to extend PINS placement shall be filed at least blank days before expiration of the placement.
60.
Oh, yeah, you're right. I didn't remember that. Shit. Okay. In a PINS proceeding, a judge may order restitution of up to...
$1,000.
Yes. Okay. All right, more questions. Which of the following two statements are correct? 1. In determining jurisdiction, age of respondent at the time the need for supervision allegedly arose is controlling. And 2. Proceeding initiated after respondent's 18th birthday shall be dismissed.
I think they're both true.
Let me see. I'm not sure.
Or is it when the petition is filed?
Oh, yeah, both are correct. Sorry.
Okay, so could you say them again, just like as true statements?
Yeah. Okay. In determining jurisdiction, the age of the respondent at the time the need for supervision allegedly arose is controlling. And the proceeding initiated if a proceeding was initiated after the respondent's 18th birthday, it shall be dismissed.
Okay, so it's at the time the need for supervision arose, but if it's started after he turned 18, then it's going to be dismissed.
Right.
Okay.
Because you know that a PINS must be under 18.
Yes, must be 0 to 17.
Yes. Okay. All right. 2. Which of the following 4 statements is correct? I'm just going to do correct. A PINS shall not be detained in any prison, jail, lockup, or any adult facility.
That's true.
Yes. B, a PINS shall not be detained in a secure detention facility.
Not be detained. That's true.
C, detention in a city with population of 1 million or more shall be in a foster care facility.
That is true. I always screw that one up, too, that it's a foster care facility.
I know. You know what? I didn't know. Shit, a good thing we're going over this, because I didn't remember that one either. And D, If a youth is 15 or older, court shall not order detention unless the court determines and states in the order the special circumstances which exist to warrant such detention.
Now that is false because it's 16 or over.
Yes, 16 or older. Okay. All right, 3. No person may be detained for more than blank hours or the next day the court is in session, whichever is sooner, without a hearing before a judge should determine if court has jurisdiction. No person may be detained for more than blank hours or the next day the court is in session, whichever is sooner, without a hearing before a judge should determine if court has jurisdiction.
So because you said hours, I'm going to guess 72 hours.
Yep.
But I probably would not have guessed that if I didn't
Yeah.
hear the hours.
72 hours
Okay.
for jurisdiction. Where's number 4? Okay. Which of the following statements is true? A. At fact-finding hearing, only material, relevant, and competent evidence may be admitted.
Yes, true.
Determination must be based on proof beyond a reasonable doubt.
Also true.
At dispositional hearing, only material and relevant evidence may be admitted.
True.
Adjudication at the end of a dispositional hearing must be based on proof beyond a reasonable doubt.
False.
Yes, it is. What is it?
I think it's preponderance.
Yes, preponderance of the evidence.
Okay.
5. Placement may be for a period of blank months, and court can extend for an additional blank.
God, is it
Wow,
12
I don't-
months?
I don't remember. I have to check the answer. Yes, 12 months. Fuck. I gotta go over this.
Ugh.
Okay. 12 months, and it can be extended for an additional...
12 months, probably.
year.
They
It
love
says
12
year,
months.
but- It says year, but I don't know if it's supposed to be 12 months. Okay. Next, 6. Petition to extend placement shall be filed at least 60 days before expiration of period of placement. A court can extend placement for up to 1 year. Pending a final determination on the petition to extend placement, court may temporarily extend placement for a period not exceeding 45 days. What the hell?
Oh, I have no idea.
Wait, hold on. There's more.
All right.
Successive extensions of placement may be granted, but not beyond the respondent's blank birthday without respondent's consent, but in no event past the respondent's blank birthday.
Oh my God. All right, I'm going to go with 8 to the first age, I'm going to go with 18th. The second age, I'm going to go with 21st.
Yeah, that's what it says, but then when we were in class...
Wait, is this the 23rd? They changed
Yeah,
something to 23rd.
Yeah, I don't know if it's this one, because we did a different one. I think it was in JD, and it was 23rd birthday.
Shit, I don't remember. But I
There
know
was
that there's one that's a 23rd.
I think it's JD. I gotta look. I'm gonna look
Oh.
at my now. But if it was just the JD, then this one would be different than that one. Does that make sense?
Yeah, it could be. One was definitely 23rd.
I know, because I remember thinking like 23. Really, it's weird. This is for JD placement. Upon the expiration of the initial period of placement or any extension thereof, the placement may be extended in accordance with Section 355.3 on a petition of any party or the Office of Children and Family Services after a dispositional hearing for an additional period not to exceed 12 months, but no initial placement or extension of placement under this section may continue beyond the respondent's 21st birthday or for an act that was committed when the respondent was 16 years of age or older, the respondent's 23rd birthday. Restrictive placement for designated felony acts for a juvenile delinquency. Any designated felony finding requires court to decide whether or not restrictive placement is required. Where the order is for restrictive placement in the case of a youth found to have committed a designated Class A felony act, the placement with the Office of Children and Family Services for an initial period of 5 years, initially confined in a secure facility for not less than 12 months nor more than 18 months, and then placed in a residential facility for 12 months. Placement can be extended for 12 months on a petition of any party, Office of Children and Family Services, or a social service district. If it's not a designated Class A felony, the initial period would be of 3 years, initially 6 to 12 months in a secure facility. No placement can be extended beyond the respondent's 21st birthday, or if they're 16 or older, it's their 23rd birthday.
This is a fill in the blank. Is to provide a due process of law for considering a claim that a person is in need of supervision and for devising an appropriate blank for any person adjudged in need of supervision.
Oh my God, an appropriate
order of disposition.
Oh my God, I don't even know anything like that.
All right, here's the next one. What is the proper venue for a PINS?
Where the alleged acts occurred.
Yes.
Okay.
A peace officer or police officer is authorized to take a youth who has run away from home to a facility certified or approved by blank.
The Office of Family and Children Services, or whatever that thing is. OFCA or some shit.
718. A peace officer or police officer is authorized to take a youth who has run away from home to a facility certified or approved by
the Office of Family and Children's Services.
OCFS. Same thing. If the officer is unable or if it is unsafe to return the youth to his home or to the custody of his parent or PLR, blank shall inform a parent or other PLR for such youth.
The what? A blank?
Who has to inform the parent?
The officer?
That's what I thought too, but it's actually the facility.
Oh, but oh my God. So with the adolescent offender, they have to immediately notify the parents?
Yeah.
But with a PIN, just the facility that they take them to?
Well, it says that if the officer is unable to, or if it is unsafe to return the youth to his home, or the custody of the parent or PLR, then they take him to the facility, and then the facility informs the parent.
Okay, again, that's not in my notes.
Okay. Detention of a person alleged to be or adjudicated a PINS shall be authorized only in 1. A blank certified by OCFS.
Facility?
Foster care program certified by OCFS or a certified or approved family boarding home or a non-secure detention facility certified by OCFS. Whenever detention is authorized and ordered for a PINS, New York City, shall direct the detention in a blank established and maintained pursuant to the social services law.
A foster care facility?
Yes.
Oh, God, I got one right.
It is hard. I have a star next to this one. 724. If a peace officer or police officer takes into custody or if a person is delivered to him under this article, the officer shall immediately notify the parents or PLR that he's been taken into custody. After making every reasonable effort to give notice, the officer shall A. Release the youth to the custody of his parents or PLR upon a blank without security that the person will produce the youth before the lead agency designated in that county at a time and place specified in writing. And I'll give you a hint. The answer is not a family court appearance ticket.
Oh, shit. That's what I was going to say.
That's what I guess every time, too.
Upon a summons?
A written promise.
A written promise? Where is that?
724.
None of this stuff that you have, I'm like seeing anywhere. Oh, no, wait, I do see it. I have, immediately, okay. I have police or peace officer receiving a PINS under section 723 shall A, immediately notify the parent or person legally responsible or person with whom PINS is domiciled, and 1, release the youth to their custody upon the written promise without security that they will produce the youth as a designated agency, or 2, take the youth to a lead agency in a county or designated facility for questioning or home on parents' consent, or D, a reasonable period of time for questioning is affected by the child's age and presence or absence of parents.
So I'm going to read it. All right, so we already got the written promise of the person to whose custody the youth is released that he will produce the youth before the lead agency designated in that county at a time and place specified in writing, or forthwith and with all reasonable speed take the youth directly without first taking him to the police station house to the blank in the county in which the act occasioning the taking into custody was allegedly done, unless the officer determines that it is necessary to question the youth. Do you want to do the first blank?
Yeah, family court?
I thought it was the designated lead agency.
It's not family court?
I don't think he could take the family court until he tried to exercise all these other options.
Oh my god.
Because I think you just read it.
Can we start it over again?
Yeah.
Okay.
All right, so do you have a subdivision B there of 724?
I do.
And does it say forthwith and with all reasonable speed?
No.
Okay. How does it start?
It just says, B1, release the youth to their custody upon the written promise without security that they will produce the youth at a designated agency. Or 2, take the youth to a lead agency in the county or designated facility for questioning or home on parents' consent.
So it says subdivision A, after making the reasonable effort to give notice, and it's every reasonable effort to give notice, the officer shall A, release the youth to the custody of the parents or PLR upon a written promise without security that the person will produce the youth before the lead agency designated in that county at a time and place specified in writing. Or B, forthwith and with all reasonable speed take the youth directly and without first taking the person to the police house to the designated lead agency located in the county in which the act occasioning the taking into custody was allegedly done, unless the officer determines that it's necessary to question the youth, in which case he may either take the youth to a facility designated by the fucking chief administrator as a suitable place for questioning of youth, or upon the consent of the parent or PLR to the youth's residence and question him there for a reasonable period of time. What is reasonable is based upon the youth's age, etc.
Okay.
Then it goes into...
Yes, but mine says in sub B that you take the youth to the family court in the county of the act.
No.
So what's right? That's not right?
No. You can't take the person to the family court until if I'm the officer, I have to try to do all these other things before I could take him to the family court. I got to try to take him home to his parents, release him to his parents with a written promise. Then I got to try to take him to the designated lead agency. Or then if it's like a runaway or something, I could take him to a respite services or crisis intervention thing. And then only if I couldn't do any of those things, then I could take him to the family court in the county, and I would have to affirm on the record that I attempted to exercise A, B, and C options and was unable to exercise them, and the reasons I wasn't able to exercise those options. They can file a petition, or that the respondent appears to be sexually exploited, but only if the person consents to the filing of the petition.
Right, okay.
All right.
Okay.
733. Who may originate a proceeding under Article 7? And there's 6 of them, so see how many you could name.
A peace officer or police officer. a person who was the victim of something that they did.
You need 3 more.
Oh, the presentment agency, if they're going from a JD
Yes. 2 more.
Fuck.
All right, I'm gonna give you a hint. I'm gonna give you a hint.
Okay. A witness?
And the last one you're never gonna get, because I forget this one too. Recognized agents of any duly authorized agency, society, association, or institution. So the total of the way that it reads is it's police officer, peace officer, the complainant, the witness, the recognized agents, or the presentment agency. It doesn't actually say parents, but like the parents could be the witness or the person or whatever that saw the, you know.
Right, they could be the complainant, obviously.
Yes. So,
Okay.
737. Service of a summons and petition shall be made by delivery of a true copy thereof to the person summoned at least 24 hours before the time stated for appearance. If requested by a person acting on behalf of the respondent or by a parent or PLR, the court shall not proceed with the hearing or proceeding earlier than blank after such service.
Can you read that again?
Sure. Service, this is 737. Service of the summons and petition shall be made at least 24 hours before the appearance. If requested by someone acting on behalf of the respondent or by a parent or PLR, the court shall not proceed with the hearing or proceeding earlier than blank after such service.
Is it 3 days?
So again, if requested by one acting on behalf of the respondent or by parent or PLR, the court shall not proceed with the hearing or proceeding earlier than
3 days.
after such service, and that is 3 calendar days. If, after reasonable effort, personal service is not made, the court may, at any stage in the proceedings, make an order providing for substitute service in the manner provided for substituted service in civil. True or false?
Oh, fuck. I didn't know you were on another question. Sorry.
Okay, so it's true. After reasonable effort, personal service is not made, the court may, at any stage in the proceedings, order substitute service in the manner provided for substitute service in civil.
Oh, yes, yes.
Okay. What is next? Oh, this is an interesting one that we literally just went over today, and I didn't know about it. So everybody knows that a certificate of warrant expires 90 days, right?
Yeah.
This is talking about in Article 7, the warrant itself expires in how long?
Oh, shit. The warrant itself? Does it not expire?
No, it does. It expires in 6 months.
Oh, fuck. I was going to say 6 months if you said that.
And can be renewed for another 6 months. Unless the respondent waives a determination that probable cause exists to believe that he is a PINS, no detention under Article 7 may last more than blank.
No detention may last for more than 3 days unless the court finds that such probable cause exists under criminal standards, blah, 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 or unless special circumstances exist warranting the extension for an additional 3 days, exclusive of Saturday, Sunday, and public holidays.
Okay, so which one is the one where it's Saturday, Sunday, and holidays?
If they want an extension.
So the initial thing is 3 days, and then the next one is 3 business days.
Yes.
Okay, so then the next question I have is 747. In an Article 7, a fact-finding hearing shall commence not more than blank after the filing of the petition if respondent is in detention.
Oh, shit. You would think, like, I haven't even looked at this shit. Oh, my God. Is this 3 days again?
Yes.
Okay, there's, like, a lot of 3 days.
I know. I guess in Article 7, if I'm not sure, I'm going to guess 3 days. All right, so let me read that in the, like, as if it was a sentence. In Article 7, PIN's fact-finding hearing shall commence not more than 3 days after the filing of a petition if respondent is in detention. Okay. Do you have that in your notes, too, in 747?
I have, if they're in detention, the fact-finding hearing shall commence not more than 3 days after the filing of a petition.
Okay. Then the next one says, this is also 747, if the respondent is in detention, the court may adjourn the fact-finding hearing on its own motion or motion of petitioner for good cause shown for not more than blank.
3 days. A lot of 3 days. I remember, like, a lot of 3 days.
What is it with 3 days? Okay, so then on motion on behalf of the respondent or the parent or PLR for good cause shown, the adjournment may be for...
oh my God. It's like a, what the fuck? I can't get the words out. Like a reasonable time or something?
Yes.
Oh my God.
A reasonable period of time. Then it says, successive motions, so I guess you're going to make a motion, to adjourn a fact-finding hearing may only be granted under special circumstances. Now, to me, I don't know what that means. Does that mean the calendar's full? So, like, I'm going to just say, no, you can't have Tuesday. I don't care if it's 3 days. I don't understand.
I'm going to be out. It's the summer. I'm taking my boat out, so.
Yeah, like, what does this mean? All right. The court shall state on the record the reason for any adjournment of the fact-finding hearing. So just a note that I have here. So the adjournment in the juvenile delinquency, it's 10 days if it's court or petitioner. In this one, it's 3 days.
Okay.
If it's respondent in juvenile delinquency, it's 30 days. And this one, it's a reasonable period of time.
Okay, I thought it was 20 days in JJ. So
and then the court shall state on the record, I'm going to try to get myself holding a microphone here, on the record, any reason for any adjournment of the fact-finding hearing. There we go. Oh my God. Okay. Next, the foster parent or any pre-adoptive parent providing care to the respondent shall be provided with notice of any permanency hearing, and the person shall have the right to be heard, but shall not be a blank.
Shall not be a complainant?
A party.
A party, okay.
So this is the foster parent or any pre-adoptive parent or relative providing care to the respondent shall be provided with notice of a permanency hearing, but they are not a party. They have the right to be heard, but not a party. And that's in 741A. Do you have a note there about it?
If there's, at the initial appearance, the respondent parent shall be advised, 741A. The foster parent or any pre-adoptive parent or relative providing care for the respondent shall be provided with notice of any permanency hearing held by the social services official. That's all I have.
Okay, so they have the right to be heard, but they're not a party. Okay. Before accepting, now this is 743. Now this is talking about an admission. Before accepting an admission, the court shall advise the respondent of his right to a blank. To a fact-finding hearing, yeah.
Okay, fact-finding hearing. Fact-finding hearing.
Okay, now it says, the court shall also ascertain through allocution of the respondent and his parent or PLR that the respondent, and then he had to do these three things. 1, committed the act to which the admission is being entered. 2, is voluntarily waiving his right to a fact-finding hearing. And 3, is aware of the possible specific dispositional orders. And then it says, the provisions of this subdivision shall not be waived. So now, in criminal court, how many times do you hear them say, they waive the reading, they waive all this, everything.
Yeah.
In this one, they shall not waive it.
So they have to hear everything, even if they have an attorney.
Yeah. And then it says, upon acceptance of admission, the court shall state the reasons for its determination, shall enter a fact-finding order. The court shall then schedule a blank.
Dispositional hearing?
Yes.
Oh my god.
All right, now these just keep getting really hard, so can we do some of your easy ones?
Yeah, so we don't feel so stupid.
Yeah, because I'm
I
going to
don't
feel really stupid when we do these.
So I don't feel so stupid?
I feel really stupid because I did most of these earlier today, and I don't remember them.
Okay. Where were we on? Okay. Oh, hold on. Okay. Notice of motion, including the court's own motion, for a new hearing or to stay, modify, set aside, or vacate an order must be served at least blank days before the return of the motion.
7
And-
days?
Yes. Wait, let me just make sure. Yeah, 7 days.
7
Okay,
days.
good.
Now, can you just tell me again what this motion is for? Because this question was actually on my one test.
A motion for a new hearing or to stay, modify, set aside, or vacate an order must be served at least 7 days before the return date of the motion, and an answer must be served at least 2 days before the date of the motion.
So this is a motion in pins for a new fact-finding?
It's let me see, 761. It says as per 761. Hold on. Fact finding or dispositional hearing, both.
Both, okay. So this one is 7 days. 7 and 2 for a new
7.
fact-finding or dispositional hearing. Okay.
Yes. For pins is
0 to 17.
yes. Choose the best answer. For a person to be found to be a pins, he must be found to need A. Supervision or confinement, B. Treatment or confinement, C. Confinement, D. Supervision or treatment.
D.
Yes. At a PIN's dispositional hearing, the standard of proof is
Preponderance.
yes. Choose the best answer. At a PIN's dispositional hearing, evidence must be
Material and relevant.
mm-hmm. A PIN's proceeding is originated
By the filing of a petition
oh, I'm sorry. Where is a PIN's proceeding originated?
where the acts allegedly occurred.
Yes. A pinned blank must be served at least 24 hours before the time stated to appear.
Summons and petition?
Yes. Which of the following choices listed lists at least one party who cannot originate a PIN's proceeding? A. Witness, duly authorized agency, police officer. B. Presentment agency wishing to substitute a PINS for a JD. A victim of a PINS. C. Parent or friend. D. Peace officer acting pursuant to special duties.
I'm going to go with C.
Yes, with the one with the friends.
Yeah.
Yeah, see, I got that wrong because it says at least one party. I didn't know what it was. I'm like, everything's right. Yeah. Okay. On its own motion, the court may substitute a blank petition under Article 10 for a petition to determine whether a person is in need of supervision.
Neglect.
Yes. The court must issue a warrant in an FCA Article 7 proceeding if
Must?
yes.
I don't
Do you know-
do they ever have to must?
Yeah, I don't know.
Oh, okay, so then I know the list, but I didn't know it was a must. It's when the
I don't-
summons can't be served, the person refused to obey the summons, the person's going to leave the jurisdiction, or
Yeah.
the respondent on bail or parole has failed to appear, or the summons would be ineffectual.
Yeah.
But I can't believe that's a must. I didn't know that that's a must.
Oh, no, it's not. It said it should read the court may.
Oh my God, I was going to say, what the fuck?
I know, I was going to say too, like, I never heard a must.
Yeah. But is that the list correct, those 5?
Yeah? Yeah.
No, yeah, because I think that list is like, seems to repeat itself over and over again.
Yeah, it is. It's the same thing.
Same thing. The only one that's different is in Article 8. it says the petitioner's safety is in danger or something.
Oh, yeah, because it's like the order of protection
Yeah.
shit. Yeah. All right, this is the last one I have. Penn's police records shall be kept in files separate and apart from the arrest of adults and shall be withheld from public inspection. For good cause shown and upon a written court order, they shall be open for inspection to 1. A parent, 2. A guardian, 3. Next friends, 4. Attorney of the Penns.
I think is all of them.
I don't know. 17.
This is probably important too because it's sealing.
Yeah, all of them. All of them.
All right, so read it again as if it's like a statement.
Okay. Penn's police records shall be kept in files separate and apart from the arrest of adults and shall be withheld from public inspection for good cause shown and upon a written court order. They shall be open for inspection to a parent, a guardian, a next friend, and the attorney of the Penns.
Okay.
And that's all I got.
Okay. Oh, that's it? Oh, so we gotta go back to the hard test?
Yeah, the shit one. Oh my god.
Damn it. Damn it.
Oh, I might have some other questions on my other test, so let me see.
All right, well, let's do a couple of hard ones, and then we'll go back to that.
Yeah.
All right, here we go. After a finding, the court shall enter an order of disposition, discharging the respondent with a warning, suspending judgment for a period of blank.
1 year?
Yep.
Okay.
Continuing the proceeding and placing the respondent for blank.
Placing the respondent?
Yep. And I don't know this answer. Oh, wait, no, I do. Okay, I do. So the
6
placement.
months? Is it 6 months or something?
12 months.
Oh, 12 months. Okay.
However, the court shall not place the respondent where the respondent is blank years of age or older unless there's special circumstances.
Is it, I'm gonna guess, 10 or 14?
16.
Oh, fuck, 16.
At least we're back to the hard test.
Oh my gosh. Alright, so can you say that again?
Yeah, it's the court can't place the respondent when he's 16 or older unless there's special circumstances, and the court states these special circumstances in the order. Okay, so the probation period in Article 7 shall not exceed blank.
Oh shit, I just read this. Is it 1 year?
Yes.
Okay.
And in
1 year.
juvenile delinquency, it's
2 years.
yep.
Okay.
In cases,
And in criminal misdemeanor, it's 3 years.
yeah. In misdemeanor, it's 2 or 3 years for an A misdemeanor. For a B misdemeanor, it's 1 year.
And then for felony, it's 5.
3, 4, or 5.
3, 4, 5. Okay.
Yeah. Okay, so this says in cases of involving infants over blank and less than blank, the court may recommend restitution not to exceed blank.
Is it over 10 and less than 18 or something like that? Over 10 and less than...
16?
Well, this says 16.
I think
Well-
that's right.
Okay. 7:58. Oh my god, I'm messed up now with all the freaking 17-year-old shit now. It's less than 16, yeah. Okay.
And adjournment in contemplation of dismissal in a PINS is a period not to exceed blank.
6 months?
Yep. Who can make the motion for an ACD?
The Pins, the court, and the DA? Or whatever. Whatever.
It says either party or the court.
Whatever, you know what I mean.
I know you mean. It's just funny. The ACD can include an education reform program if the acts involved blank or blank.
What? A fucking what? An educational what?
Reform program. And when I tell you the answer, you're gonna be like, what the fuck? This is brand new too. It's from 2018.
If they like stopped going to school or some shit, if they were smoking weed in school. Wait a minute. Okay, say that again.
It's cyberbullying or sexting.
They can get an educational reform shit.
Yeah.
So they can learn how to bully and sexually assault kids and sex.
No, it's to tell them not to do it anymore, I guess.
It's like when we get the sexual harassment.
Which
like,
I need to go for that again, I'm telling you, because I don't fucking know what it even means.
What?
I don't understand. I don't understand what it is.
Sexual harassment?
No, I don't. I've been to different trainings, and in one, it made sense. It was like, and then the other one was like, how is that sexual harassment?
All right, well, if you grab somebody's...
No.
If you grab a guy's dick on a train, you're not only a pervert, you're sexually harassing them if it's done at work.
Oh my god.
Oh my god.
Okay, next.
I really wanted to ask some guys that at work. I think I'm going to do that on Monday.
Don't, that would be sexual harassment.
Hey, do you think that...
But you have to freeze it like, you can't be like, if I did it. Because they'll be like, oh, Dorothy, you know, she's pretty cute. I would like that. It has to be like some random doing it.
Oh my god.
Pick like the most, like, I don't know. Oh my god. Okay, next. If the court requires restitution for the public good, the court shall require an agency or person to supervise the restitution or services. And the agency or person must report to the court not less frequently than every blank unless the order provides otherwise.
Oh shit. Is it like 3 or 4 or 6 months?
I think it's 6 months. For some reason, the number 6 months is sticking out in my head. And this is in 754.
My first reaction was 6 months, but then I'm thinking about something with 3 months. But
There is something with 3 months. I don't know what it is, though.
But I think it's like totally different article.
All right. Do you have 754 in your notes?
754. Yeah. Okay.
Says the court requires the restitution of services for the public good as a condition of probation or suspended judgment. It shall provide that the agency or person supervise the restitution or services, and that such agency or person report to the court not less frequently than every blank unless the order provides otherwise.
Where is this? 754?
Yeah, really think it's 6 months, but I don't know.
I don't even see this in 754.
Okay. I'm going to stop recording and check the app then. The answer is 6 months.